Good evening. Senior Advocate Shri Firdos Mirza sir, Advocate Abhay Samre, President High Court Bar Association Nagpur, Advocate Srirang Bhongadi, Secretary High Court Bar Association Nagpur, Senior Advocates and my dear friends, and all esteemed members at the bar. I, Advocate Richa Inamdar Tiwari, Treasurer of High Court Bar Association Nagpur, on behalf of the entire Executive Committee of the High Court Bar Association, extend a warm welcome to everyone present here, despite it being a rainy day. I truly appreciate that you all have made efforts to grace this session of the late Shri Vinod Bobde Senior Advocate Memorial High Court Bar Association Study Circle. Today, we continue our academic calendar with a vital and intricate subject in criminal jurisprudence, nuances of bail and anticipatory bail in criminal jurisprudence. It is now my great honor to introduce Senior Counsel Shri Firdos Mirza sir. Hailing from a small city of Yavatmal, sir built his practice entirely on his own merits and ability without the backing of a senior's office. A stalwart of the profession with a distinguished legal career at the Nagpur Bench of Bombay High Court, he has served as a standing counsel for the High Court Administrative Side, the Maharashtra State Works Board, and Central Excise and Customs Department. Sir was formally designated as a senior advocate in the year 2024. His profound contribution to jurisprudence is widely recognized through landmark appearances in significant public interest litigation concerning the tribal welfare, education, public health, and infrastructure, as well as his appointments as amicus curiae by the High Court in matters of public profound importance like the Shregao Development Project, regulation of school buses, and many more. Beyond his practice, Sir is an accomplished author, a regular columnist for Lokmat Times. Sir is also an expert member on various academic boards, including the RTMNU Law Department, and has been honored with prestigious awards such as National Youth Award, the Shastri Gaurav Puraskar, and the Mahatma Phule Talent Search Award. Sir, we are extremely grateful to have you with us today. I now request President Advocate Abhay Samre sir and Secretary Advocate Srirang Bhongade to kindly escort our esteemed speaker to the dais. It is our absolute privilege to have Sir's esteemed presence illuminating us on this topic today. I request Advocate Abhay Samre, President High Court Bar Association Nagpur, and Secretary Advocate Srirang Bhongade to welcome Sir with a sapling. Thank you, sir. I now request our esteemed speaker to kindly enlighten the bar on today's topic.
Thank you, Advocate Richa. President of the Bar, my friend Abhay Samre, Secretary Mr. Bhongade, Vice President, and my old-time friend Ganesh, Khanjode Sahab, past President of District Bar Association, Mr. Kamal Satuja, Additional Government Pleader, Shri Deepak Thakre, the Executive, Office bearers, friends. First of all, a big thank you to all young friends, because they are present in such a large number considering the weather. Because of this weather condition, I was about to request for postponing this. But the executive committee was bound to have it today only. So thank you for attending it. Advocate Richa Inamdar Tiwari. Because since the day when she joined the profession, she is Richa for all of us. She introduced me, and I came to know that, oh, really? But one thing before starting or touching to the topic, I must clarify. She has introduced me saying that I have done everything without having support from any senior office. This is not true. The fact is that, no, what she said is the correct position. I never had any senior in High Court. The reason was I practiced in the district court for more than 7 years. There I worked with my senior, and after practicing for 7 years at Yavatmal, I shifted to Nagpur. And being in practice for 7 years, there was no further need of any senior. But it is my conviction that without a senior, we cannot stand on our legs. I always say this, that स्वयंभू सिर्फ महादेव है, उसके अलावा कोई नहीं होता. So we are not Mahadev. So we must have a senior, we must toil with a senior, we must learn with a senior. We learn by observing the senior. Though I was not having any official senior, but all the seniors at that time, I used to attend their hearings, I used to sit with them, I used to read their files, visited many senior offices. So, now let us come to the topic. When there were other options, this topic was forced on me, especially by Isha, Miss Isha Thakre. She said, no sir, you need to take this. Because when I started my practice at Nagpur, means in High Court, in the year 2003, for around 4 or 5 years, I used to practice exclusively on criminal side. It happens. Then client took me to different courts. Now, very rarely I get an opportunity to appear in criminal courts. But still she was after me, so I agreed. So nuances of bail, don't pronounce it, though it appears to us as nonsense. Because bail is such thing, the only field of law which you cannot fit in any straight-jacket formula. You don't have clear law on bail. You have only provision that this court can grant bail. Under these provisions, these courts can't grant bail. But how the bail is to be granted, under what provision, there is no law governing the field. It depends on discretion. Therefore, it may be nuances, but the other word also applies many times, because we are not able to tell our clients why the application is rejected. It happens. So don't be disheartened. So let us start. That how, please keep one thing in mind. We are not in law college now. We all are practicing lawyers or attached to some offices as interns. We have completed studying CRPC, IPC, now BNSS and BNS. We are here to learn practically how those laws, principles apply, what practical is to be done, no theory. Forget the theory, let us come to practice. Now, preparing a case. When will you prepare a case? For preparing a case, there is a requirement of one client. So first the client has to come to you. So my entire thesis will start with after the client reaches your office. The client comes to you, tells your problem. Clients tell you that he was on the moon, sometime on this star, and this thing happened on the earth, and he is implicated. Are you going to buy this story? इस कहानी पर कौन भरोसा करेगा? तो क्या करना चाहिए हमने, क्योंकि आपको तो उसकी कहानी कोर्ट को बताना है. Now what is exactly the role and place of a lawyer in the entire system? Like the telecom companies, they send the information from this place to that place. For that, either they use cables, Wi-Fi, Bluetooth, or so many different machineries. They transfer the information from here to there, information technology large. So exactly what lawyer does? Lawyer has to transfer whatever is in the mind of the client to the brain of the judge, without using any of the wire, cable, internet or anything. But you have to transfer with a filter. You cannot transfer everything. There has to be some filters. So when client comes to you, what you should do? Number one, the foremost is verification of credentials of the applicant, that is your client. You must verify who is he, because you are not knowing him. Ask for his identity documents. Otherwise, many times it happens that somebody else came, told that he is so and so person, affidavit in his name, identification by the lawyer, and lawyer is also an accused. This happened. So first and foremost, you do verification about the credentials, that who is he. Number two, don't listen to his story alone. Read the contents of FIR, and if the charge sheet is filed, charge sheet also. Read complete contents. So how will you read it? Because sometimes 5,000 pages, 10,000 pages. There is a catch. While you are verifying the credentials, he narrates his story. You have his name. Now, most of you, though we are from the older generation, I have never seen our president with any iPad in a courtroom. But most of you use it. You scan the documents, then you do something what is called OCR. OCR is for making that document readable. It is for themselves. We cannot do it. Still, I can't do it. So in OCR, put name of your client in search engine. It will give you the name wherever it appears. Read those documents. That will show what are the allegations against him, or what is been shown against him, or whatever implication is there. If you can't do that, then again go to charge sheet. Charge sheet is in always different parts. The first part broadly shows you what are the charges that the police want to press against your client. Go to that part, read it. If it is only FIR, from FIR only take that part which is against your client. Then listing the chronology of events, the one of the most important thing. Don't start directly dictating the bail application. Jot down. कि भाई हाँ, सबसे पहले क्या हुआ, तू कब पैदा हुआ, वहां से शुरू मत करना। एफआईआर में जो फैक्ट्स दिए हैं वो कब से शुरू हो रहे, नोट डाउन डेट वाइज, not necessary to use the iPad and pen, sometimes paper pen will also do. Note down the chronology. Why chronology is important? Because my experience is, while noting down chronological events, in fact, draft of my application is complete. After that, details of informant. First, we have taken details of our client, then take details of informant. Sometimes he says, साहब वो जिसने रिपोर्ट दिया उसका कुछ नहीं है, उसके पीछे कोई और है. So take that information also कि वो कौन है, कि कौन से विदेशियों का हाथ है इस केस में. Take that information. तो कौन है, why? Because enmity is one of the basic grounds for false implication. Then the most difficult part which I faced, examining the sections mentioned in the FIR in the light of FIR. What are the allegations? Sometimes they mention the sections in the top part of the FIR. I have not brought the FIR because, as I said, that I am talking with the lawyers, not the students. So there are sections mentioned, but the allegations go somewhere else. Only 2 persons are involved, and the section for dacoity is there. Is it possible? In technical offences like Essential Commodities Act, they mention section 7, but fail to mention the control order which is violated. They mention the control order but fail to mention which of the clause is violated. It happens in many such technical offences. Therefore, examine what is the section. After doing that, go to version of the applicant, because otherwise if you take his version first, you will not be able to do all this exercise. क्योंकि राम कहानी तो आखिरी में सुनने का. So he will tell his Ram kahani. Okay, after his story, take the documents of his defense, whatever are there. List them also. Take out whatever is of helpful. Those which are not helpful, don't annex, only for his satisfaction, because you are going to face the court. Sometimes the unnecessary documents brings the trouble. Many a times what is not in the charge sheet, you yourself bring it on record along with that document, and police get that. Then study the relevant act, rules, government resolutions, circulars. When we started practice, most of the cases were used to chaku churi. So that time these were useless. But now white collared crimes are there. And you have to appear in those cases. Like recently there was a matter regarding the teacher's appointment. One portal was there, on that portal the information was to be uploaded. And many teachers, joint director of education, deputy director of education, education officer, all were accused. But MEPS Act doesn't have any penal provision. So where will you go? How it is to be done? So you have to search for GRs, the rules that govern the appointments, and then you have to build a defense that, look, whatever I did, it was as per rules. And there are 2 terms, illegality and irregularity. If I am committing some illegality, it may be penal, but irregularities are not penal. If you can bring your client from illegality to irregularity, he is out on bail. Therefore, reading those relevant act, rules, government resolutions, circulars are very important. According to me, most important document is that circular. Because daily government offices are issuing circulars, putting one circular in this pocket and bringing out another circular from another pocket. Self-contradictory. You don't bother, they will help you. Because you have to create only doubt while arguing the bail. Then research of case laws. Now how you will do it? So I always complain with my colleagues, especially the junior colleagues who are very tech savvy, because they are too fast in research. Even better than AI. My brain cannot match with their speed. But they do this research on machines. And I do with the books. I take help of their research, then go to books. Why? Because while reading books, first of all, by default we read the contents. Then when we open the book, the judgment didn't start from the top of the page. There is some other part of other judgment on that page, then this judgment starts. And unknowingly I read that judgment also, this judgment also, and at the end another judgment starts. Somehow I read some part of that judgment also. So though the same one judgment is of help to me, but the two judgments which I read, the contents which I read, the glossary which I read, it is stored in subconscious mind and it is used later on. So with research, take the knowledge also. And for knowledge, you do it. Have it in hybrid mode. Search for one judgment, the best judgment you take out, you will get the genre of other judgments. There the Supreme Court or High Court refers to earlier judgments. Go to them also. But do it with the books. If you don't have books in your office, our library is very good. And our librarian is doing very good job for that. And what will you do with the case laws? Sorry. After the research, what will you do? The best thing is, never do the research after filing of your application. First, complete your research on that topic. From the best judgment available, whatever is of your help, take those paras, put in your draft. Because when you will cite that judgment, you can quote from your application that, look, my application is identical. The facts are identical. The law is, what I have pleaded is there in the judgment. That will help you. Then the most difficult and easy part. Because you have done everything. Who has not done the earlier exercise, for him it is difficult. Who has done the earlier part, easiest thing. So what could be the format of drafting? For this, my office colleagues have prepared two drafts. One is for a regular bail application, one is for anticipatory bail application. Please collect it while going out. Why I have given? My understanding is that as you grow older, you get busier, you get less time to read. So I always feel that on one page, from one page you could be able to argue your complete bail application. The first page. So the bail application should be drafted in such a manner that looking towards only one page, you should be able to tell the court the entire facts. You should be able to understand what are the provisions of law against you, who is who. That you will get. In that, what I feel, what should be there, don't twist the story while writing. Because keep in mind, when you are there arguing your case, there is an opponent counsel, the governmental counsel, the APP is there, sometimes assist to prosecution is there, to point out if you have twisted the story, if you have tell something false, if you have not stated the truth or in the FIR or whatever is in the FIR is suppressed. Why to give this opportunity? Judge is also going to read it. So, even as an officer of the court, it is our duty to tell whatever is there. Then defense will come. So, allegations exactly as they appear in the FIR. Sir, these are the allegations against me. If you suppress something, only on that ground bail will go away because judge will be prejudiced that you have suppressed. Write it down. It is always better to point out what is against you instead others pointing what is against you. पहले ही बताओ भाई मेरे खिलाफ ये है. तो जब वो अपोनेंट शुरू होगा तो ऑलरेडी आपकी बात तो कोर्ट के सामने आ चुकी है, तो कोर्ट के दिमाग में रजिस्टर नहीं होती है. टेक माय वर्ड, I have spent more years. The applicant's story of innocence without opening the defense and status of the applicant. This is very important part, without opening the defense. You state the story of applicant that my story is this, but that should be in relation to the informant. Your defense, what you are going to take if the trial is going to come. If you take that defense today, the investigating agency, it will alerting the investigating agency, telling them what to do. Take all this. These lacunas, you just fill up. You may take them in arguments, but don't write, never give the documents as I told earlier. The relevant facts about the informant or the circumstances leading to registration of the FIR. Many a times, facts are different and FIR reads something else. You mention that. Many times, your client is clean slate and the informant is having 5 or 10 offenses against him. That is very important and relevant factor. Many times, exactly opposite things has happened, but he has reached earlier to a police station. And the FIR is registered. We all know from the practice that though there are so many checks and balances against the police force, but still our police is in the British era. Law Commission at various times given this suggestion that the dande wala police and pain wala police should be different. That means the police on bandobast, the law and order, those police should be separate, and for the investigation part, the detectives should be different. But still the government is not listening. He is doing the both thing. Whole day he does the bandobast duty and evening he writes down the Panchanama. So their approach are different. Still we get the complaints that the police stations are not still the complainant friendly, the informant friendly. Mainly they are not the victim friendly. These allegations we regularly get. So what happened? Many a times he went there, but already the accused is sitting there and he is the informant against you. And your client is booked, though he is a victim. So therefore, the relevant facts are very important, the circumstances leading to the FIR. Now these are the fundamentals. So these are gist of all whatever material available on bail. That how the bail, the courts consider grant and rejection of bail. Nature and gravity of accusation. Many times the offense occurred by accident. A single injury. Injury on non-vital part. Multiple injuries, injuries on vital part. That makes the difference. intentional offense, unintentional accident, or accidental offense. So if the court feels that it is an intentional, it is a grave, you have acted overtly, you went beyond your defense, then it is a grave and you will not get bail. Therefore, you need to bring it to a lower pedestal, that it was accidental, it was not grave. Therefore, you just study it. Then, as I earlier said, criminal antecedents of parties, very important. Today, if you are aware, the Supreme Court ordered for release of all the students and other agitators, subject to, there is a asterisk, if they are not having any criminal antecedents. Therefore, risk of the applicant fleeing from justice. Many times we write down XYZ, applicant XYZ, aged about major, resident of Nagpur. Because the first step we have not taken. The first thing what I said, take the credentials. It will be used here. Give detailed address. If possible, mobile number, email, give in the application itself. That shows that you have roots in the society, you are not going anywhere. Because for trial takes many years still in India. So the only bail's first consideration is whether you would be available for the trial or not. So there is no any chance of your fleeing away. You have to prove that. Apprehension of non-cooperation. That if you are left on bail, you will get this MLA, MP, minister to help you and you will pressurize the system. In some way you will purchase the witnesses. You will not go and attend the police station if required, if condition is there. You will not report to investigating officer whenever you are called. So add a para for that yes, I will do it. Show that if anticipatory is granted, file an affidavit that I have appeared on so much dates. Possibility of accusation made in bad faith. Courts consider this. And for that, your expertise as a lawyer, the most important thing. You have to bring a wheel. एक पर्दा बीच में लाना है. जो इन्फॉर्मर ने बोला है और जो आपकी कहानी है, आपकी कहानी का पर्दा बीच में आना चाहिए. जो ये बताए कि जो इल्जाम है वो गलत है, वो किसी दुश्मनी की वजह से, बदमाशी की वजह से किए गए, इन बैड फेथ. Implicate your client. He has not done that serious thing. Then we have two types of bails basically. One is anticipatory, then regular. So I have tried to prepare a draft. I said you will be getting this. So the top is like that. The anticipatory bail, that heading you forget it. That is just for today. Don't add it in your application. Then I have given the details. In some cases like atrocities, sexual assault, you need to write down the name of informant also. But to cover it. On cover it is XYZ and behind the cover the name is there. Now it is 482 of BNSS. The most important part. I said that from looking towards a single page you should be able to argue the matter. FIR, that is crime number, date of FIR, time, date of incident and time. Why it is important? Because the delay in registration of FIR, antedated FIR, both things you could be able to point out. Then whatever are the sections and act, who is the informant, if any application was made earlier. We write it at the end, but write it there only. And if the answer is yes, give the number also. Many times court calls it. That helps the court also make it easier for them whether to take it matter or send to the same judge if he is available, or to take it, because now the both type of views are there, whether to send it or not. And this shows that you are transparent. You are placing every information before the court. You are not withheld any impression. The judge is happy with this. The first impression of your application, that you have given entire information, you are not held anything back. The applicant is peace-loving citizen. Maybe having one or two offenses, but still. Because, as I said, that earlier offenses were by accident, but still he is peace-loving. Having deep roots in the society. He is earning his livelihood by, don't say that any illegal activity, that he is a drug peddler. Don't write here. Instead of labor. Then he has no criminal record. But if he has criminal record, don't write here. Write it downwards. Then remove that. Then para 2, what I do is write the FIR, details of FIR. Then my practice is in para 3 is like that. The allegations in simple language without any addition. Whatever is in the FIR, in simple language. These are allegations against me. Then the sections, what is the maximum punishment on the sections which are applied. Because this is the part of preparation. Many offenses are not punishable for more than 3 years, 5 years, 7 years. Though they should not arrest, but they are getting arrested. So we are in anticipatory. So there is no need of arresting, but the police want it for some oblique reasons. So write it down. Whether it is cognizable, whether it is non-cognizable. In many non-cognizable offense, the police doesn't look the books and you are booked. Whatever your pleadings are, add them. Then again, if you have preferred an earlier application, the sessions judge, the details of session judge application. Then regarding your cooperation, write specifically. Then again, only red dot is not. Whether you have, if preferred, then remove the not and give the details. Then the prayers. In sessions court, we file 2 applications. One is the main application, another is for the interim relief if you want. But in High Court, we file a single application consolidated with both prayers. But keep in mind, while making the prayer, be specific regarding the offense. Write it down. By repetition, no harm is going to cause. But in the days of cut and paste, please be sure to read it twicely. Otherwise, the FIR number and offense of your earlier bail application will be there, and before the judge you will be a very sorry figure. So read it, write it down, be specific about police station, your district and sections also. Sections along with the act, name of act. Because the judge is going to grant you bail. After reading your prayer only, he will dictate as per your prayer. Then you will have to come with the application for speaking 2 minutes, correction of order and all. Till that time, your client is in the air, running here and there. Then affirmation is important, and then regular bail. Regular bail, the first part would be like that only. The second also, the allegations, but with an addition, the applicant was arrested from which place? You write it down. on because he is in jail. Which is the date? Why it is important? Because you can show that since so many days and months I am behind the bars, there is no necessity of my custody. Why to keep me inside? For that. Then if charge sheet is filed, write down the completion of investigation. Then the sessions, rest is the same. Here the prayer is only one. Then who will file the affidavit? There are two options. One is affidavit by a person who is his relative, brother, sister, wife, or anybody else. Write down, I am conversant with the facts of this case. Because you are not lawyer, he is not a lawyer, he cannot take instruction from him. So I am conversant. Or if there is nobody at here, many a times you get the information, get the application from legal aid, nobody is there. Who will file application? So give a note. This is also permissible. You will get the draft. So these are the drafts. So while arguing this, now you have filed the application. While arguing, what is the best part? According to me, for good cases, you need to argue minimum. No need to argue at length. The fundamentals you have seen. The only feature for bail is what you need to argue is whether your custody is required. That's all. We are not arguing a matter for quashing of FIR. There is a difference between quashing of FIR and bail. While going for quashing of FIR, the principles given in the Bhajanlal's case, they will come, but not in the bail. Bail, the only thing, whether your custody is required, whether you would be available for trial, that's all. So custody. If the investigation is done and everything is being seized, tell that everything is seized. Why? What for? Now these are two types of bail. There is one more which is being nowadays after this new BNSS and BNS. Though there is no provision for that, but a new challenge is coming before us. Recently, there was a matter of a leader of a national party that he spoke something in a state in South India and the offense was registered in Assam. A Maharashtra leader of one case, he said something in Maharashtra, he was booked in Gujarat. Now the bail powers of bail for a district judge or sessions judge is limited to his district. High Court is said to be a court for a state. And for entire country, the Supreme Court is there. And the trend in Supreme Court, unfortunately, is to say to no to all petitions under Article 32. It is really unfortunate. Because when the architect of our constitution, Dr. Ambedkar, was asked that which provision of constitution according to you is most important. So without wasting a second, he said that Article 32. Why? He said that Article 32 is soul of the Constitution. So the next question was why? He said that Article 32 is a fundamental right of every citizen to approach Supreme Court for enforcement of his fundamental right or making a complaint regarding violation of fundamental right. So bail is a fundamental right because it is curtailing your liberty, your right to life. So in such circumstances, you may approach it. But under what provision other than Article 32? Because everybody cannot go to Supreme Court. So a concept of transit bail. Concept of transit bail is incorporated. And in a recent judgment of Honorable Supreme Court says that though it is said that High Court is a topmost court of a state or the union territories which are attached to it, but there is no limitation to its jurisdiction. And it can grant bail for transit period for few days till you approach the jurisdictional court. It is a new avenue, and for that you note down a judgment that is 2024 4 SCC 749. This is the last judgment on this point, because later on those judgments came, they considered only this judgment, this basic judgment by Justice Nagratna and Justice Bhuyan. Priya Indoria's case. That gives, enlightens you on the concept of anticipatory bail also, as well as the transit bail. It is one of, according to me, at present, this is the best judgment on that line. Then a new concept the Supreme Court has created for release of your client immediately by asking only one question, whether the reasons of arrest or grounds of arrest were given to him or not. You must read that judgment also. That is Mihir Shah's judgment. My friends who are practicing before the trial court, for them it is nowadays very helpful judgment. These two judgments, rest all judgments, I leave on you for studying them. You will get the entire list in the 2024 judgment. You must read all those judgments which are mentioned in 2024. So these were the all theories and practical tips on bail. Bail, in fact, is a very small chapter. But for juniors, that is the way to establish their practice. So focus on that. We cannot advertise. Recently, Supreme Court said that Bar Council to take action against those lawyers who are advertising about themselves on the social media. Be aware of that. Never place these things on social media. The Bar Council may take action. You will get fame by mouth publicity only. Many times the complaint of the clients are that their lawyer doesn't listen to them. He doesn't listen to their story. Sometimes you have to act like a psychologist also. That is our destiny, that nobody comes to us with a smiling face. Everybody comes with a lot of tension. But when he leaves you, he should have a smile on his face and a faith in you. For that, in first meeting at least you should listen to him. Then restrict him, otherwise he will waste your time. So for that you listen to him. These are the tips. So if organizers permit, can we take one or two questions or no need of question? If anybody wants to, but not related to the matter which is pending on your table or in the court. So I hope I was not clear enough, therefore there are no questions. So okay, there is one.
Sir, in many cases, the weapon mentioned in the FIR, which is actually not used, but in regular bail, the police said give the weapon. In that case, what action we can?
What you should do? Ideally, you should not cooperate. But the result is more days of PCR. So, in fact, this is recording, so I cannot give you my opinion. I'll tell you later. So, friends, read between the lines what I said. So, thank you very much. I am thankful to the executive president, secretary, the executive body, and especially all of you, my friends, to be here, and the executive body again to grant me this opportunity to connect again with the young friends. So, thank you. I am here, we all are here, and for the executive committee once again that you have restarted this exercise of study circle. I must congratulate you and thank you for this. Thank you.
Thank you so much, sir. That was truly enlightening session. The wonderful insights you have shared today have given us a much deeper understanding of the nuances governing personal liberty, statutory provisions, and judicial discretion in the matters of bail. Your guidance is something we will carry in our daily criminal practice. To conclude today's academic endeavor, I invite the Joint Secretary of HCBA Nagpur, Advocate Palash Mohta, to propose a vote of thanks.
Respected esteemed speaker of today's function, Senior Advocate Shri Firdos Mirza sir, esteemed member of the bar, distinguished guest and all other present here. On behalf of High Court Bar Association Nagpur, it is my proud privilege to propose this vote of thanks on the occasion of late Shri Vinod Bobde Senior Advocate Memorial Lecture Series. Today's lecture on the topic Nuances of Bail and Anticipatory Bail in Criminal Jurisprudence has been an intellectually stimulating session. We are deeply indebted to our esteemed speaker, Senior Advocate Shri Firdos Mirza sir, for sharing his vast knowledge, practical wisdom, and experience on the subject that lies at the very heart of the criminal jurisprudence. We are sure, sir, that not only the junior members, but everyone present here has learnt a lot today. I would also thank the Office of Senior Advocate Firdos Mirza sir for their efforts for making this lecture a success. I also thank Advocate Arjun Bobde for his valuable gesture towards the benefit of the bar members. I sincerely thank all the advocates, members of the bar, particularly the younger advocates who have enthusiastically participated in this function. My sincere appreciation also goes to the Registry of the Bombay High Court Nagpur Bench, whose dedicated efforts have ensured the successful organization of this lecture. Finally, I once again express our deepest gratitude to Senior Advocate Shri Firdos Mirza sir for graciously accepting our invitation. Thank you, sir. Before we part, there is a refreshments in the cafeteria. Please join our speaker there.